The establishment of the Commercial Court in Uganda, one of the 5 divisions of the High Court in 1996, was a timely response to a changing business landscape in the country. As the economy became more liberalized and a number of state-owned enterprises were being privatized, it became clear that privately owned business expected faster and timely disposal of commercial disputes in order to promote economic growth and attract investment. The Commercial Court, the first in Africa, has since been a model in Uganda and other countries. Its structure highly respected and sought after in setting up commercial courts across the continent, as well as building their capacity to make them functional.
The Commercial Court was established as one of the elements that were required to reform the commercial justice system. The other elements were the reform of the commercial laws, the company law, partnership, banking. The reform of the laws themselves was found to be necessary to bring them in line with the demands of the business community.
The other reason was promote prompt enforcement of business contracts. There was more or less a culture in this country where contracts could be breached and with impunity, and there was no effective enforcement mechanism to remedy the situation.
The court is one of the few divisions of the High Court which has a purpose-built courthouse. It is specifically designed and built to deal with the needs of the business community. With its unique procedures and being a multi-door court, it has improved access to justice for users. Through use of alternative dispute resolution and mediation, lawyers can be appointed as court annexed mediators to deal with a number of disputes that are now being resolved without going before a judge. The court also hosts a Center for Arbitration and Dispute Resolution and collaborates with the Pepperdine University School of Law, all of which open doors to court users who wish to explore arbitration and mediation.
We have 9 mediators, and we have rooms where the parties can go for mediation. This is important because even though you file a case today, you will not be able to get access to a judge tomorrow. Sometimes it will take between 60 to 120 days even before the case can come up for trial or even mentioned before a judge. So instead of having the case sitting in the registry, we use that period to allow parties to go through a process of mediation.
Judges who used to deal with different categories of disputes, ranging from criminal, civil, and family matters all together under the old system, now have got a chance to concentrate and hone their skills in delivering commercial justice.
It provided specialization. Specialization meant there was a facility put aside specifically to handle commercial cases. And that enabled the commercial court to concentrate, to build capacity, to build skills and expertise in handling commercial disputes. It also enabled the court to establish special procedures to enable the business community to expedite the hearing of their cases.
The Commercial Court has dealt with backlog by establishing standards of performance in the customer's charter. It has clearly stated that cases should be completed within 6 months and short cases should be finished within 3 months. This has brought down the number of days which a case would take before being disposed of.
We have a very rigorous pre-trial procedure that we follow in the Commercial Court, and that makes it easier for us to determine whether a case is ready for trial or it is not. We only give dates to cases where we're absolutely sure that the parties are themselves ready for trial, that they have given negotiations a chance and those negotiations have failed. They have their legal paperwork in order. They have all the documentation that they will require during trial. They have all the witnesses that they will require during trial. This is just to make the whole process more efficient and effective.
The establishment of the Court User Committee, which meets on a quarterly basis, provides a continuous feedback system about the standard of service of the court. The court users can make contributions and get faster response regarding how the affairs of their commercial court are run. This is a constant source of information on aspects that need improvement.
The Commercial Court Users Committee has been extremely useful in ironing out the administration of cases. Because we have this forum where the commercial court users interact with the judges to help both sides understand the processes and the challenges each side meets. And in these meetings, the judges and the registrars will say, for example, URA, which is one of the commercial court users, the problem is that when you come to court, your cases are not ready, or you don't bring the right witness at the right time, and so that creates challenge. On our side, we come and say, we will make these improvements, but would you help us and not issue interim orders ex parte? So that interaction has helped remove, I think, a lot of the impediments we experienced previously. And this is one way the court is made more efficient.
Technology is used throughout the entire process to ease the work of judges and judicial officers. Courtroom technology, particularly the recording of court proceedings, saves the judges man-hours that would have been spent writing proceedings in longhand. It has thus improved efficiency and effectiveness.
I use speech recognition, which allows you to write using voice, and it's very efficient and fast system, faster than typing or writing in a longhand. The advantage of using court recording is that a judge can concentrate on looking at the documents that are being submitted, looking at the witnesses, what they are saying, whether they are being truthful, and to concentrate on presiding over the trial rather than writing.
In its continuous pursuit of innovation, the commercial court is currently in the process of piloting a complete e-court environment, which will allow for both audio and video presentation. It will also make it possible for court users to use e-filing of documents in a paperless environment where everything is digitized. This will improve preservation of court records and eliminate instances of case files or records getting lost. It will further improve transparency in the court, thereby building the confidence of court users in the system. To further improve efficiency, all parties need to ensure that the right sort of cases come to the commercial court division and that there's better preparation for the cases that come. Once the lawyers and their clients have done good preparation, they will spend just the amount of time required to present just the right issues for the court to deal with. That will be the best way to use the commercial court. The court users or litigants are central to this process.
They should monitor what their lawyers are doing more closely because sometimes you find lawyers coming to seek an adjournment simply because they have not been able to meet their clients and agree maybe on, say, to testify or even to provide some vital information that is needed for preparing the joint scheduling memorandum. So my advice would be that, first of all, the litigants should be following up their cases closely. They should also give full instructions, make available to their lawyers all the documents that relate to that case to prove it. They should also make sure that they pay the lawyers so that the lawyers don't have excuses for not coming to court.
The commercial court, which was set up to deal with the cases that directly affect the economic life of the country, is fully open for business. The business community are making use of its services for resolution of disputes, interpretation of contracts, and other services they require out of the court system, and this has helped the national economic growth and the ranking of Uganda as a good business destination. To pass on some of the lessons learned from the successful procedures at the Commercial Court, the Chief Justice's Rules Committee passed the Small Claims Procedure Rules in July 2011. This will ease resolution of smaller commercial disputes of value amounting to less than 10 million Uganda shillings, or $4,000 equivalent. Small claims will be handled by magistrates because they're spread across the country, and that will help business continue to function, as well as unclog the mainline courts of the bulk of cases relating to small business.
The procedure is very simple. We have designed forms which can be used to start the case and also to defend the case. And therefore, there will be no need to use lawyers. You will actually be able to conduct the case yourself. The procedure is supposed to be very informal and fairly quick. We believe really that when the case starts, from start to judgment, should not take more than probably an hour or so. So you really come and go away with your judgment. After all, we're looking at an expedited form of justice.
The business world being dynamic, it needs a modern judiciary to match it with modern service delivery. The Commercial Court in Uganda is constantly trying to innovate so as to adapt best practices that are now being replicated in other divisions of the High Court. As it continues to succeed, some of the factors for its success also become its challenges.
There's a high demand for the use of the Commercial Court because virtually 60 to 50% of the disputes in this country are either land matters or commercial disputes. Now, with that, maintaining the same number of judges, when there is an increment in the demand for the use of the service from this court, is a challenge. It's a challenge to us, the users, and is a challenge to the litigants, and is also a challenge by way of a burden on the judges.
Adoption of new innovations is part of the solution.
Courts promote reconciliation between parties. So when parties go in for full trials, it makes our work cumbersome. That's why we have introduced alternative dispute resolution, ADR, so that parties who have disputes can appear before judges and resolve their disputes without necessarily going through the hassles of full trials.
The business community need to appreciate the new way of doing things, that in the commercial world, negotiation is actually the norm. It is not contestation, because agreements are consensual, whether it is a loan, whether it is a contract to buy a house. So negotiations is one of the cardinal features of the commercial world. So mediation promotes that concept, and if you should only, the case should go for trial only when there has been a failure to reach the final agreement on the dispute.
The Commercial Court in Uganda continues to make big strides in delivering to the business community an efficient, expeditious, and cost-effective mode of adjudicating disputes that directly affect the economic, commercial, and financial sectors of Uganda.